agreement's validity is parliamentary ratification or parliamentary approval. The mere signing of the agreement is not what gives it validity, as was held by the Supreme Court in the Faro Atlantic case and the Balkan Energy case. And so it is important for me to stress that this GPGC emergency power agreement that the ex-Wal Mahama administration entered into was not only approved by cabinet and signed by the then Minister for Power, Honorable Kwamina Donko, but it was approved by Parliament in line with Article 181 Clause 5 of the 1992 Constitution. And the MPP side in Parliament at the time participated fully in the approval process, both at the committee level and at the plenary. Now, ladies and gentlemen, it is worthy of note that among the EPAs executed by the government of Ghana, the GPGC EPA was the one with the most favorable terms for us as a country. Firstly, it had a capacity charge of 4 US cents per kilowatt hour, with GOG's payments denominated in Ghana cedis. And secondly, it had the shortest duration of 4 years. Thirdly, and more importantly, it was the only EPA under which the government of Ghana was not required to provide any financial guarantee or standby letters of credit. Now, ladies and gentlemen of the media, the implementation of the GPGC EPA proceeded smoothly until the Mahama NDC administration, under the Mahama NDC administration, until the Akufo-Addo-Bawumia government took over the reins of power in the year 2017. On 13th February 2018, the Minister for Energy, Honorable Boachie Ejiakon, wrote to terminate the GPGC EPA. The termination of the GPGC EPA, according to Boachie Ejiakon, was on the instructions of Cabinet, which is chaired by no less a person than the President of the Republic, His Excellency Nana Addo Dankwa Akufo-Addo. It is instructive to note that the reasons which were cited by the Akufo-Addo government as the basis for the termination of the GPGC EPA did not include any issue of excess power or excess capacity charges, as government will have us believe now. Rather, the reasons which were contained in Boachie Ejiakon's termination letter of 13th February 2018 and the advice of the then Attorney General, Gloria Akufu, dated 28 August 2017, bordered on alleged non-performance of certain conditions precedent and subsequent by GPGC, namely, 1, the failure of GPGC to secure a license from the Energy Commission to enable them engage in the sale of electricity in the country in accordance with Section 11 of the Energy Commission Act. 2, failure of GPGC to secure a siting and construction permit for the project. 3, failure of GPGC to achieve financial closure, that is to secure funding for the project. Now, I want to show you a copy of this termination letter. So if the guy controlling the screen can show us the relevant portion of Boachie Ejiakon's termination letter. If you look at the paragraph which has been circled in red, or which has a red rectangle around it, what it says is that we also note that to date, GPGC has not reached financial close nor achieved full commercial operation dates, primarily because some of the preconditions, conditions subsequent for the, can we see the next page? for the achievement of financial close and full commercial operation date have not been fulfilled. Now, if you look at the third paragraph, it says that similarly, although it is a requirement to obtain siting and construction permits from the Commission prior to the construction and installation of a plant for the production and supply of energy, GPGC has commenced construction on site without the requisite siting and construction permits. Accordingly, GPGC's construction activities are illegal. Then even before that, if you look at the paragraph above, it says that the ministry has been informed by the Energy Commission that GPGC has still not obtained a license from the Commission, that's the Energy Commission, to engage in the business of commercial activity, the business or commercial activity for the sale of electricity. GPGC, therefore, has no capacity to execute the EPA. Accordingly, the EPA is null and void for want of capacity. Now, the letter concludes by saying that in view of the above, the government of Ghana has taken a decision to terminate the agreement effective the date of this letter due to GPGC's breach of its obligations under the agreement. And so, ladies and gentlemen, I have shown you Boakye Akon's termination letter, the letter he claims to have written on the instructions of the Akufo-Addo chaired cabinet, for you to appreciate the reasons that informed government's decision to terminate this agreement. And those reasons did not include the issue of excess power or excess capacity charges, as the current Attorney General and government spokespersons would have us believe. Distinguished friends from the media, all these claims by the Akufo-Addo government, which formed the basis for the termination of the GPGC EPA, were found to be contrived and baseless by the Permanent Court of Arbitration of the United Nations Commission on International Trade Law. At paragraph 479 of the arbitral award, all the three arbitrators, and I repeat, all the three arbitrators, including Ghana's selected arbitrator, the internationally renowned arbitrator Professor Fiajo, unanimously held that these claims by the Akufo-Addo government did not reflect the true facts. The tribunal, among other things, noted that GPGC had actually secured a building permit from the Konkatamanso District Assembly for the Blue Ocean project, and had actually applied for a commercial license from the Energy Commission, save that President Akufo-Addo had not constituted the board of the Energy Commission, which is the body mandated by law to issue such licenses at the time the agreement was being terminated. Additionally, the tribunal found that all the conditions precedent and subsequent that were yet to be fulfilled were wholly attributable to the failings on the part of the government of Ghana and not GPGC. In short, ladies and gentlemen, the arbitration tribunal found that the termination of the GPGC EPA by the Akufo-Addo Bawumia government was wrongful and without any lawful justification, for which reason the panel unanimously awarded damages of about $170 million against the Republic of Ghana, and this figure is inclusive of interest. And so, ladies and gentlemen, on your screen is paragraph 479 of the arbitral award by the Permanent Court of the United Nations Commission on International Trade Law. And it is very clear from this paragraph that the reasons that government based its decision to terminate the GPGC EPA were all frivolous and baseless. If I can just run you through that quickly, it says that whether or not Dr. Ahenkra's evidence to the tribunal was correct when he testified that none of the information said by the Attorney General to have been elicited on inquiry of the Energy Commission was provided directly by the Commission. Now, let me just read the relevant portions. It says, rather, all correspondence had been between the Commission and the Ministry of Energy. It is evident on the record available in this arbitration that the premises upon which the AG's advice was founded did not reflect the true facts. First, as Dr. Ahenkra was obliged to concede, and Dr. Ahenkra is the chairman of the PPA committee that this government claims to have recommended the termination of this GPGC EP. Now, the tribunal goes on to say that the AG's advice was founded. Let me take it again. It is evident on the record available in this arbitration that the premises upon which the AG's advice was founded did not reflect the true facts. First, as Dr. Ahenkra was obliged to concede, the board of the Energy Commission, which was the body charged with approving a provisional generation license, had not been reconstituted when GPGC has submitted its application in July 2017. That remained the case at the time the Attorney General was preparing her advice. Second, GPGC did have a building permit for the Blue Ocean site issued by the Pon Katamanso District Assembly, and GOG has not been able to adduce any statute or regulation, including the Energy Commission Act, which addresses the requirement for any additional construction permit. Third, the nature of the GPGC equipment to be used for these works was expressly described in the EPA, and it had been inspected and approved for use by the ministry in June 2015. And so, clearly, the reasons government gave for the termination of the GPGC EPA were all frivolous. And so if you go to paragraph 493 of the arbitral award, if we can see paragraph 493 now, the International Arbitration Tribunal held that in light of these conclusions, the tribunal must consider the proper measure of damages to which GPGC is entitled by reason of GOG's, that is Government of Ghana's, wrongful termination of the emergency power agreement. So this paragraph settles the issue of Nahukosan, how we got here, why we are being made to pay this judgment debt of $170 million. The court is very clear on that. And they said that it is because of the wrongful termination of the EPA. Now, ladies and gentlemen of the media, it is crystal clear from the foregoing facts that are contained in the arbitral award that this huge judgment debt of $170 million has been occasioned by the criminal negligence, incompetence, and recklessness of the Akufo-Addo government. Their willful recklessness in terminating the GPGC EPA on the basis of contrived and frivolous excuses is the reason why Ghana has been slapped with this avoidable judgment debt. Friends, it will surprise you to know that after the GPGC EPA was terminated and the company appealed to government to rescind its decision, the Akufo-Addo government, acting through the Minister of Energy and his deputy, conceded that the termination was wrong and gave the company several assurances that the President and Cabinet were going to take remedial steps to reinstate the terminated EPA. I want to repeat this paragraph for emphasis. because it is very, very revealing. Friends, it will surprise you to know that after the GPGC EPA was terminated by the Akufo-Addo government, and the company appealed to government to rescind its decision, the Akufo-Addo government, acting through the Minister of Energy and his deputy, considered that the termination was wrong and gave the company several assurances that the President and Cabinet were going to take remedial steps to reinstate the terminated EPA. Evidence of this fact is contained at paragraph 486 of the arbitral award and settles the fact that indeed President Akufo-Addo, the Minister of Energy at the time, Boakye Jaakon, and the Attorney General are jointly and severally responsible for this $170 million financial loss to the state. Now, can we see paragraph 486 on the screen? We are showing you the relevant portions of the arbitral award so that you can better appreciate the issues and see for yourself the reasons that inform the decision of the International Tribunal. Now, this is what paragraph 486 says. If you can come down a bit. The record before the tribunal bears out that submission, in particular the following. A. On 13th March 2018, GPGC was told that the Minister of Energy would advise Mr. Edu, Deputy Minister of Power, to write a memo to the President and the Cabinet of Ministers to seek the reinstatement of the EPA. B. On 16th March 2018, in the course of a meeting between representatives of GPGC, led by Mr. Duncan and Deputy Minister Edu, the latter assured GPGC that efforts were underway to reinstate the EPA. C. On 4th April 2018, Mr. Edu informed GPGC that the President of Ghana had verbally approved the reinstatement of the EPA and instructed the Energy Commission and Mr. Opam to ensure that GPGC could resume construction as it did on 24th April 2018. And D. On 3rd May 2018, in response to its letter of 26 February 2018, GPGC was told that the ministry is working on the issues raised in your letter and will revert to you soon with our response. So this portion of the arbitral award shows clearly that the Akufo-Addo government knew that the termination of the GPGC EPA was wrongful. They knew and acknowledged that they had no basis to terminate the agreement. Yet they proceeded to terminate it and failed to remedy same by reinstating the EPA. What is even sad in all this, ladies and gentlemen, is the fact that Ghana is now going to pay a whopping $170 million as judgment debt to a private company for a deal which would have cost the nation $99.6 million. That is $24.9 million per annum over a 4-year duration. And that is if the agreement had been maintained and not terminated by the Akufo-Addo government. So instead of paying $24.9 million every year for 4 years, leading to a total of $99.6 million for 107 megawatts of power that we could use or export to other countries for revenue, we are now going to pay $170 million in judgment debt. Meanwhile, we never got the power. Now, ladies and gentlemen of the media, the NDC has taken notice of certain false claims by the Attorney General and Minister for Justice, Godfrey Adame, and spokespersons of the Akufo-Addo government that the decision to terminate the GPGC EPA was based on a recommendation by the Ahenkra PPA committee that reviewed a number of PPAs executed by the previous NDC government. And we have seen a report making rounds on social media, and we've seen a portion of that report recommending that the GPGC EPA be terminated and an amount of $18 million paid by the Republic of Ghana to the company. Now, if we can show you that report, if we can show, that's paragraph 3I of that so-called report by the PPA committee. That recommendation says that government may consider terminating the PPA of GPGC executed between government and GPGC with an installed capacity of 107 megawatts at an estimated cost of $18 million, or else pay excess capacity charge of 24.9 million per annum over the contract period of 4 years. Now, this is the recommendation that the Attorney General and Minister for Justice, Godfrey Adami, claims formed the basis of government's termination of the GPGC EPA. But friends from the media, our painstaking investigations into this matter shows that the claim that the PPA committee recommended the termination of the GPGC EPA is palpable falsehood. In fact, this claim, which is contained in an unsigned report, and this report is unsigned, making rounds on social media, was part of the defenses of the Akufo-Addo government, which were outrightly dismissed by the International Arbitration Tribunal in their decision. It will interest you to know that during cross-examination at arbitration proceedings, Dr. Ahenkra, who was the chairman of the PPA committee and a key witness for the government of Ghana, said that he could not recollect any such recommendation by the committee and dissociated himself from the AG's advice that recommended the termination of the GPGC EPA. This fact can be found at paragraph 490 of the arbitral award. And this is how much the Akufo-Addo Bawumia government derelicted in its duty to protect the public purse. So let's see paragraph 490 now. It's on your screen. It says one of the PPAs recommended for termination was the GPGC project. And ladies and gentlemen, I'm reading from the decision of the court. That's what I mean by arbitral award. Dr. Ahenkra's committee suggested that termination could be achieved for some $18 million as opposed to payments of $24.9 million a year for 4 years in excess capacity charges. The basis of that recommendation is not known. The copy of the PPA committee report submitted into the record by Government of Ghana is heavily redacted, meaning heavily edited. Notwithstanding the tribunal's order that the unredacted text be disclosed. Under cross-examination, Dr. Ahenkra equivocated. That's what I want you to see. Dr. Ahenkra equivocated as to whether he had any recollection of the particular recommendation made in respect of the GPGC EPA at all, just as he had sought to distance himself from the AG's advice of August 2017. So if it is true that the PPA committee chaired by Dr. Ahenkra recommended for the GPGC EPA to be terminated, why did he deny knowledge of same when he appeared before the International Tribunal? And why did he dissociate himself from the legal advice of the then Attorney General and Minister for Justice, Gloria Kufu, that recommended the termination of the GPGC EPA? Friends, does it not strike you as strange that Dr. Ahenkorah did not bother or see the need to ask the arbitration tribunal for leave to refresh his memory by referring to the committee's report, which was the main essence of his testimony? Now, it is also instructive to note that after the Ahenkorah committee concluded its work, officials of the Akufo-Addo government gave several assurances to GPGC that its PPA was not one of those which had been recommended for termination by the committee. And this fact is captured at paragraph 491 of the arbitral award. So they actually told the company that, look here, the PPA committee has concluded its work. They've recommended for government to terminate some EPAs, but your agreement is not part of it. It is not one of those PPAs affected by the committee's work. And so you have nothing to worry about. So how come that this so-called recommendation for the EPA to be terminated was smuggled into the report? If you check paragraph 491, which is on your screen, it says that false assurances, and this is the decision of the arbitration tribunal, false assurances were given by the government of Ghana in October 2017 that the GPGC project was not one of those unaffected as a result of the review. No, let me take it again. False assurances were given by the government of Ghana in October 2017 that the GPGC project was one of those unaffected as a result of the review, and that it enjoyed the full support of the minister and of Mr. Opa. This fact begs the question as to how the said recommendation, which formed the basis of the termination of the GPGC EPA, found its way into the unsigned report of the Ahenkorah-chaired PPA committee. In any case, how come that the said Ahenkorah committee report was not signed by the chairman and members of the committee? Friends, as I've already indicated, our painstaking investigation into this matter shows that the said recommendation was fraudulently inserted into the draft Ahenkorah report by political actors who were determined to terminate the GPGC agreement at all costs, even though they very knew they had no lawful justification to do so, and that doing so could potentially occasion a judgment debt and financial loss to the state. We in the NDC believe that the circumstances surrounding the smuggling of the said recommendation into the Ahenkorah committee report raise issues of fraud and must be investigated. And ladies and gentlemen of the media, we've also taken notice of desperate attempts by the Attorney General Godfrey Adame and some individuals to impugn the propriety of the GPGC EPA, which was executed under the NDC Mahama administration. These people have suggested that the GPGC EPA was unnecessary and its terms defective. But friends from the media, nothing could be further from the truth than this claim. In the first place, how can the MPP, who fully participated in the approval of the GPGC agreement in Parliament, both at the Mines and Energy Committee level and at the plenary, turn around to question the propriety of same? It is important to make the point that aside the fact that the GPGC EPA was approved by Cabinet and Parliament, its terms are materially the same as all the other PPAs executed by the then Power Ministry, some of which, like Car Power and Sem Power, have been extended by the Akufo-Addo Bawumia administration. In fact, as I've already explained, the terms of the GPGC EPA were to a large extent more favorable to the interests of the Republic of Ghana than all the other PPAs executed at the time. What even makes this claim ridiculous and preposterous is that the Akufo-Addo government itself has by its own conduct expressed faith and confidence in the GPGC agreement. The government terminated the GPGC EPA and actually proceeded to make a counterclaim against GPGC for early termination damages at the arbitration by relying on provisions in the same agreement. And this is very revealing. Any lawyer will understand the seriousness of this point, because a counterclaim is a fresh action. If you are sued in court and certain claims are made against you, and you make a counterclaim against the plaintiff as a defendant or a respondent, your counterclaim is like a fresh suit against the person who sued you. In other words, you are telling the court that the one who sued me is not entitled to these damages. Rather, I am the one entitled to these damages. And so order him to rather pay these damages to me. And a counterclaim is considered as a fresh action in law. So the question is, if, according to Godfrey Dame, the GPGC agreement the Mahama administration signed is defective, then why will you terminate that agreement by relying on provisions in that same agreement and then make a counterclaim against GPGC by relying on provisions in the same agreement? Clearly, the Attorney General and Minister for Justice cannot approbate and reprobate. It's like saying that you are a Muslim, but you eat pork, or you like pork meat. It doesn't work like that. If you think the agreement is defective, then you cannot be making a counterclaim against, on the basis of a defective agreement. So the question we are asking Godfrey Dame is this: why has the Akufo-Addo government turned around to question the integrity and propriety of the very agreement they relied on for their counterclaim? If the Akufo-Addo government thought that agreement was defective, why did they rely on provisions in same for the termination and counterclaim? And why did they not raise the issue of the impropriety of the agreement either in the termination letter of 13 February 2018 or at arbitration proceedings? For emphasis, the GPGC EPA was approved by Parliament and its terms were very favorable to the interests of Ghana. The claim by the Attorney General Godfrey Dame that the GPGC PPA was unnecessary and defective, and a subsequent threat to refer same to the CID for investigations, is nothing but a post facto face-saving gimmick, which must be treated with outright contempt. As I have already indicated, the facts show that the $170 million judgment debt awarded to GPGC was occasioned by the criminal negligence, complete dereliction of duty, and recklessness of the Akufo-Addo government in terminating the EPA without any lawful justification and not the signing of the agreement. Therefore, those who have to be held responsible are those who were involved in the termination of the agreement on the basis of fictitious and contrived claims, when they knew the danger their actions could portend for this country, and not those who signed the agreement, which was approved by Parliament in any case. Distinguished friends from the media, another point worthy of mention in this discussion is a crass incompetence and sloppiness with which the Attorney General's Department and the Akufo-Addo government handled the court processes to set aside the arbitral award. As you may be aware, at arbitration, the Republic of Ghana was represented by lawyers from the AG's department, which included the Deputy AG at the time, and now Attorney General Godfrey Adame, and a Ghanaian law firm, Ambufa & Partners. We've seen the Attorney General trying to play Pontius Pilate and create the impression that he was not involved in this whole matter, and that his attention was drawn to this case only after his appointment as Attorney General. Well, ladies and gentlemen, that is not true, because it is clear from the arbitral award that he was one of the lawyers on record. In fact, our checks show that at most of the sittings of the arbitration tribunal, he, Godfrey Adame, was the one who led the government of Ghana side. So we want to show you, maybe somebody will think that what we are saying is not factual. So let's show you an extract from the arbitral award, which has his name there as one of the lawyers who represented the Republic of Ghana. So, counsel for respondents, Ms. Gloria Ifua Okufu, Mr. Godfrey Adame, Mrs. Helen Akpene Awuziwu, Mrs. Anna Pell Ikiwumi Srebo, Mrs. Grace Opon Dolphy, all of the Office of the Attorney General and Ministry of Justice. Now, the Permanent Court of the United Nations Commission on International Trade Law delivered its final award on 26 January 2021, after which Ghana had a 28-day ultimatum to challenge same in a court of competent jurisdiction in the United Kingdom, the seat of the arbitration. The Akufo-Addo government then engaged the services of an English law firm, Omnia Strategy, which is owned by Sherry Blair, wife of Tony Blair, the former Prime Minister of the United Kingdom. And this was done at the expense of the Ghanaian taxpayer. Sadly, the government of Ghana and its external solicitors went to sleep, only to go to an English court on the 25th day of the 28-day ultimatum to ask for extension of time. The court magnanimously gave an 8-day extension to allow our external solicitors file the appropriate processes to challenge the arbitral award. Subsequent to the grant of this extension of time by the court, our external solicitor, Omnia Strategy, realizing that the government of Ghana had a very bad case and mindful of the damage the case could do to their enviable reputation, backed out of the case. The Akufo-Addo government once again engaged the services of another foreign law firm called Volterra Theatre at the expense of the Ghanaian taxpayer, who managed to file a process to challenge the arbitral award on the 1st of April 2021, April Fool Day. 23, and this was done 23 clear days after the extended deadline of 8th March 2021 had lapsed. All the excuses which were cited by the Akufo-Addo government for the delay, mainly COVID-19 and the 2020 elections with its associated handing over bureaucracies, were dismissed as intrinsically weak by the courts, and arbitration and the final arbitral award upheld. Ladies and gentlemen of the media, the NDC is appalled and disgusted by the incompetence, sloppiness, and recklessness that was displayed by the MPP Akufo-Addo government, particularly the AG's department in the conduct of this case. The AG, her deputy Godfrey Adame, who led the government of Ghana's legal team at the arbitration, very well knew that the tribunal had set 26 January 2021 for its arbitral decision. They all became aware of the arbitral award against Ghana on the 26th of January 2021, at which time their party, the New Patriotic Party, was in office. They knew that Ghana had only 28 days to challenge the award if we so wished, and they knew that an AG or deputy AG was not likely to be in office by that time. What instructions did they give to the Solicitor General or the relevant officers at the AG's department in their handing over notes? Or what arrangements did they put in place to ensure that arbitral award was challenged if it didn't go in our favor? Clearly, the current Attorney General, Godfred Yeboah-Dame, has proven to be very incompetent and sloppy as far as this matter is concerned. His desperate attempt to extricate himself from blame and shift blame to his former boss, Madame Gloria Kufu, and past government officials who left office about 5 years ago, is shameful and unfortunate, to say the least. In any serious jurisdiction, the Attorney General, Godfred Yeboah-Dame, and the Solicitor General, who are paid by Ghanaians to defend the interests of the state in legal matters, and who were actually involved in the conduct of this case, would have been held accountable or resigned by now. Now to the last issue we will address before we conclude this press conference. It has to do with the false claims by the MPP about SS capacity charges. Now, finally, ladies and gentlemen, we cannot end this press conference without responding to the false narrative about SS capacity charges that the MPP and its surrogates have been regurgitating for some time now. They claim by the MPP that the Akufo-Addo government is paying a lot of money for power we don't need, or as SS capacity charges because the actual NDC Mahama administration signed many needless take-or-pay PPAs, such as the GPGC EPA, is mischievous, to say the least. First and foremost, let me make the point that take-or-pay arrangements are normal insurance or financial viability provisions in power purchase agreements. In fact, it is not a new phenomenon in Ghana at all. For the records, the Osno, now SNET PPA, entered into by the MPP Kufuor administration, was a take-or-pay agreement. Also, the Transtema plant that was brought into the country under the Kufuor era was on the take-or-pay basis. Again, and more instructively, the Tema LNG project recently entered into by the Akufo-Addo government is a take-or-pay agreement. There is therefore nothing wrong with take-or-pay agreements per se. Also, the MPP's claim that the country currently pays $1 billion as excess capacity charges as a result of PPAs executed by the actual NDC regime has been proven to be false. When the Minister of Finance, Ken Ofori-Atta, appeared before Parliament a few days ago to answer a question filed by Honorable Hassan Suhini on the amount of money government has paid in excess capacity charges so far, he said in his answer that the country has paid a total of $937 million to only 3 companies, which are Car Power, AXA, and SemPower, from 2017 to 2020. If we can see that on the screen. If you may recall, Honorable Hassan Suhini filed a question in Parliament on this issue, and the question was to the effect, he asked the Minister for Finance which independent power producing companies have received payments from the government of Ghana for excess capacity charges, and how much was paid to each company in the last 4 years. Let's see Ken Ofori-Atta's answer. So Ken Ofori-Atta says that $937.5 million, and the money went to 3 companies: AXA $347.20 million, Car Power $359 million, SemPower $231.30 million. Now, this is payment in excess capacity charges according to the finance minister over a 4-year period. Now, when you divide this by 4 years to get the annual, average payment, you get 234 million US dollars. So they claim that the Akufo-Addo government has been paying 1 billion US dollars every year in excess capacity charges. It's not true. Because per Ken Ofori-Atta's answer, it comes down to just 234 million US dollars. But ladies and gentlemen, not all that amount constitutes excess capacity payments. And I'm going to explain that to you. It is worthy of note that about $200 million of this amount, this $234 million per year, constitutes the 20% standard reserve margin of ECG, which is a necessity and not excess capacity. So ECG is supposed to have a reserve margin of 20% of electricity they use. So that 20% reserve margin is like reserve players on the bench of any team. Those reserve players on the bench of, say, any football club are there for a purpose. I don't want to say phobia. I don't want any trouble with Fabulous fans. You know that every team, plays with 16 players, 11 on the pitch and 5 on the bench, except for tournaments where you have 18 players, right? Now the players on the bench are not SS. They are a necessity because they can be called upon to substitute those playing at any given time. So you cannot describe them as SS. Now, we've shown you that per Ken Ofori-Atta's answer, the amount of money we are paying in excess capacity charges averagely per year is $234 million. Now, out of that figure, 200 million of that is the reserve margin of ECG, like the 5 players on the bench of any football team. That is a necessity that they are required to have. You cannot describe that as excess capacity charges. The remaining $34 million worth of power would have been wiped away or wiped off if VALCO, only VALCO, had been revived by the Akufo-Addo government, or even if the AFD funded 330 kV transmission line project from Ghana to Burkina Faso, which was commenced by the ex-Wal NDC Mahama administration, and which would have ensured an increase in the exportation of power from 100 megawatts to 200 megawatts to Burkina Faso alone, not to talk of other Sahelian countries, had been completed by this government. The question we want to ask those who keep disturbing our ears with this propaganda about excess capacity charges is, why has the Akufo-Addo Bawumia government extended the duration of the car power PPA executed by the NDC Mahama administration from 10 years to 20 years, and the duration of SEM power from 5 years to 10 years, if the claim about excess capacity charges is true? Only recently, the Minister for Energy, Matthew Poko Prempeh, asked for Ghana to increase its generational capacity. As we speak, a steel manufacturing company in Ghana, located in Pampram, and I'm told they are the biggest in Africa at the moment, B5 Limited, is operating at 30% capacity due to lack of power. Where then lies the claim that Ghana is paying for power we don't need? Friends from the media, even if the Akufo-Addo Bawumia government thought that the country did not need the 107 megawatts of installed capacity the GPGC EPA was supposed to provide, or that the country could not export same for revenue as the Mahama administration had planned, the wisest thing for them to have done was to have negotiated and deferred the implementation of the agreement, just as they claimed to have done in the case of 4 other PPAs. Terminating the agreement on the basis of fictitious and contrived claims, which they knew could not be sustained and could potentially occasion a judgment debt and financial loss to the state, was not an option. After all, the maintenance and performance of the agreement would have cost the nation only $99.6 million US, with a possibility of the state exporting same for revenue. In conclusion, and as I've already demonstrated with indisputable facts in my presentation, Ghana has been slapped with this judgment debt of $170 million as a result of the reckless and wrongful termination of the GPGC EPA by the Akufo-Addo government and their sloppiness and incompetence in defending same at the arbitration and in courts. The then Minister for Power, Boachie Agyakong, who wrote to terminate the agreement, and his deputy at the time knew and actually conceded that they have no legal basis to terminate the agreement the way they did. They very well knew that terminating the agreement that way could potentially occasion a financial loss to the state. Yet, they did so willfully, knowing very well what the consequences of their actions were. They failed to take advantage of the opportunity they were offered by the company to remedy the situation or reinstate the EPA as they themselves had promised. This is why the wrongful termination of the GPGC EPA by the Akufo-Addo government and the avoidable financial loss it has caused the nation is unpardonable. As a party, we are very sad that all of us as Ghanaians will have to cough up this colossal amount of money, $170 million, which is equivalent to 1.2 billion cedis, or 10.2 trillion old Ghana cedis, and which accrues interest daily, compounded on a monthly basis. This colossal amount could have been channeled into the constructions of thousands of dormitories and classroom blocks to end the obnoxious double-track system which is undermining the quality of secondary and tertiary education in the country. Or could have been channeled into the provision of hospital beds and other facilities to end the much-dreaded no-bed syndrome, which is claiming so many precious lives. Alternatively, the huge sum of money could have been used to build roads and for other useful projects that would have created jobs and improved the well-being of Ghanaians. The perpetrators of this evil must not go unpunished. The NDC, ladies and gentlemen, hereby calls for investigations into the circumstances surrounding the unlawful termination of the GPGC EPA, particularly the alleged so-called recommendation by the Ahenkra Committee for the termination of the said GPGC EPA, which in our view raises issues of fraud. We also demand that all officials of the Akufo-Addo government who were directly or indirectly involved in the processes leading to this huge financial loss to the state are held responsible and punished for same. But in the likely event that President Akufo-Addo, the mother serpent of corruption, who is himself complicit in this matter, fails to act, a future NDC government will investigate this matter and ensure that those responsible for the wrongful termination of the GPGC EPA and avoidable judgment debt and financial loss it has caused the nation are brought to book. We thank you for your time, ladies and gentlemen.
All right, thank you very much. We would ask for questions at this juncture. If anybody has a question on this, please kindly move forward. If you have a question on this. Okay, Parker. Kindly get the microphone and then. Please, let's get the question.
I show a quick one to Mr. Jemfi. You mentioned the Ahinkra committee. I want to get clarity because you are told by the Attorney General that that committee was set up by the NPP, the NDC administration before the exit in 2016. So I want to know if the Ahinkra committee is the same committee you are referring to. That is number one. And then number two, you challenge the authenticity and credibility of the PPA's report, the one we've all seen, which you read about the excess capacity as a reason for the termination. With the arbitral award that you read to us as well, we haven't seen any signed documents. I don't know where it's coming from. How then does one admit or consider that indeed what you read to us as accept are indeed the arbitral award or the statement from there? That is number two. And then finally, the AG says they are prosecuting all those who are involved under the former President Mohammed's administration with regards to the termination or the contract. Will the NDC petition the CID as well to also get those who terminated the contract? Because you mentioned that the NDC will investigate in future. In future may be too far away from now. Thank you.
Okay. Any other, please? Any other? Any other? Okay. All right.
Okay. Since we just have one question, let me quickly deal with that. Parker wants to know whether the Ahinkra committee I refer to is the same committee which was put up at the Ministry of Power under the ex-Wal Mahama regime. Yes, it is true that as far back as September 2016, a committee was put together to review PPAs that had been executed under the Mahama administration. That committee was headed by Michael Opam at the time. I understand that when we left office and the Akufo-Addo Bawumia administration took over in 2017, there were some changes to the membership and chairmanship of the committee. So I understand that there was at that time that Dr. Ahinkra was moved from the Ministry of Energy to the Energy Commission and had to chair the committee. So under the NDC administration, there was nothing like Ahinkra committee, because the committee which was formed then did not include any Dr. Ahinkra and was not chaired by Dr. Ahinkra. I'm sure that he came into the picture after we left office. Now, you want to find out, and let me say that I've shown you the relevant recommendation in that report, which is unsigned, you understand? And that calls into question the credibility of that report, because once a committee set up to investigate, any matter concludes their work, the normal thing that happens is that in line with their terms of reference, they prepare their reports and all the members append their signatures. And so it is a bit strange that till date, government has not been able to produce a signed copy of the Ahinkra committee reports, so that we can all rely on that. Okay. Very sorry. If you can feel. Yes, very, very sorry for that. So we are saying that in view of the fact that the report making rounds on social media is not signed, in view of the fact that the chairman of the committee who took over from Mike Lopam in 2017 when this government took office has denied ever making any such recommendation as part of their work, in view of the fact that government of Ghana also gave assurances to GPGC that the agreement was not one of the agreements the committee recommended for termination, we don't believe that the recommendation for the GPGC EPA to be terminated was made by the INCRA committee. And so we are calling for investigations into the circumstances surrounding this issue. Because if the chairman says, I don't recollect ever making this recommendation, he didn't even ask for leave to refresh his memory like we do when we appear before a court. Okay, he was there basically to testify about the work his committee had done. Okay, so how come that he didn't even know the recommendation they made on the GPGC PP? And if indeed he had forgotten, couldn't he have asked the court for leave to refresh his memory by referring to the report to at least remind himself of the recommendation? He didn't do that because he was under oath, and he didn't want to lie under oath because that would be perjury. And we understand that the members of the committee have refused to sign the report because of the smuggling of this particular recommendation into the report, because this recommendation did not come from them. And they know that if they accept responsibility for this recommendation, then one day they can be prosecuted for the offense of willfully causing financial loss to the state. Because it means that they would have recommended for the termination of a PPA without any legal basis. Because clearly, as we have demonstrated to you, all the reasons that form the basis for the termination were found by the court to be frivolous and contrived. And so that is why you can see, I mean, Dr. Ahenkra, you saw Dr. Ahenkra distancing himself from that purported recommendation from the committee. And then you said, what shows that what I projected on the screen is that the arbitral award is out there. If you don't have a copy, you can come for a copy when we are done. Because it's out there. And I'm sure a lot of media houses have the soft copy. We've given you specific paragraph 490, these are screenshots. Or are you suggesting that we cooked up the report ourselves? No, it's not possible. This is the arbitral award. I have the full document there. If you want a copy, I can share a soft copy with you. I'm sure that multimedia should have a copy. And so you can check the paragraphs we gave you. 486, 490, 4914, 93, 479, and you will see that what we have projected and shown you here are actually contained in the arbitral award. Then you said that the AG has served notice that government will be prosecuting those who were involved in the signing of the agreement. Okay. Maybe he will be prosecuting the MPP members of parliament who approved the agreement as well. Because like I explained to you, the validity of an international business transaction such as this PPA stems from parliamentary approval and not the mere execution of the agreement. And anybody who has read the Balkan Energy case or the Faro Atlantic case will appreciate that. Because without parliamentary approval, the minister's signature is useless. What makes the agreement effective and operative is parliamentary approval. And in this case, the agreement was approved by Parliament with the MPP side at the committee level and at the plenary fully participating in it. Yes, and including the current energy minister, Matthew Poku Prempe, who was the minister of the Mines and Energy Committee at the time. You understand? Unless Godfrey Dame is suggesting that he understands the law better than lawyers like Papu Uswankoma and all these MPP lawyers in Parliament. And he understands power purchase agreements better than Matthew Poku Prempe and all these energy experts from the MPP side who were in parliament at the time, scrutinized this agreement and approved the agreement. What is wrong with this agreement? There's absolutely nothing wrong with this agreement. It was approved by parliament, it was approved by cabinet. The terms were the most favorable of all the EPAs. A capacity charge of 4 US cents per kilowatt hour. Car power was 5.6 cents per kilowatt hour. Sun power was 5.04 US cents per kilowatt hour. This one was 4 US cents. And GOG payments were denominated in cedis. For the other agreements, we're supposed to pay the companies in dollars. With regards to this GPGC EPA, we were not even required to provide any standby letters of credit or financial guarantee. So, what was wrong with this agreement? Godfrey Dame has not been able to tell us. And maybe he should report himself to the CID for investigations. Because he himself, as Attorney General, has relied on the agreement for a counterclaim. Meaning that he has sued under the agreement. So which lawyer in the world sues under a defective agreement? And then turns around to do what? Prosecute those who executed the agreement, when you yourself, by your own conduct, has expressed confidence and faith in the agreement, for which reason you relied on the very provisions of that agreement for your counterclaim. And in the counterclaim, government of Ghana asked for a lot of damages, millions of dollars. Maybe we should show you that as well. Paragraph 352. If you can put paragraph 352 on the screen, so that you can appreciate the double standards and hypocrisy of Godfrey Adame and the government of Ghana. Paragraph 352. Can we have it on the screen? Good. So this is government of Ghana's request. The following reliefs. Back, are you watching? Good. The respondent here is the government of Ghana. So according to the Attorney General, the government of Ghana is entitled to the early termination payments and counterclaim as follows. A declaration that the respondent, which is the government of Ghana, lawfully terminated the EPA consequent upon the claimant's breaches of the EPA. B, an order directed at the claimant to pay the early termination payment in accordance with clause 25 BRRI. C, an order directed at the claimant to pay for damages for breach of the EPA. D, an order for the payment of all costs and expenses of this arbitration proceedings, including without limitation the fees. So they wanted the company to even pay their legal fees to them, relying on the terms of the very agreement. You're claiming early termination payments, millions of dollars. So if it had gone their way, the agreement would have been perfect. But because their case was dismissed, their counterclaim was dismissed, now the agreement which he relied on is defective. So my answer to your question is simple. The agreement is not defective. The terms of that agreement, apart from the fact that they were the most favorable, those terms were not even materially different from the terms of the other EPAs, which this government has extended, like car power, like sun power. If you pick those PPAs and you compare it to this, the same template was used. You understand? So if you have extended car power from 10 to 20 years, you've extended sun power from 5 to 10 years, then what are you talking about here? And we are saying that Godfrey Dame and the government of Ghana, by relying on the very GPGC EPA, the terms of that agreement for the termination they purported to do, and by making a counterclaim on the basis of that agreement, have expressed confidence and faith in the agreement. And so they cannot be approbating and reprobating. Ladies and gentlemen, since these are the only questions we have, I will end here, and thank you very much for coming. We are unable to do. We are unable. We are unable to do that. We are unable to give you a Tree translation today, but we'll be available for interviews in the Tree language subsequently. Thank you very much for coming. We'll get you copies of the press statement before you leave. Thank you.